So very good morning, Fazal, Jaipal, Lucky, Parth and Rishabh. So let us start the.
Good afternoon, sir.
Yeah. So yesterday we studied about the registration of partnership and what are the consequences of non-registering the partnership. Okay. So that we studied yesterday, and today we will be studying about the dissolution of partnership as such, right? So let us go over there on the dissolution of partnership. Yeah. This we have already studied all things. These things you can just have a look of that how we have studied this. The rights and duties of partner, and then registration of firm we studied, and what are the effects of non-registration of firm. Besides, we have also seen that what is the mutual relationship of one partner with the other, and what are the authorities and the liabilities which the partner have, and what is the extent of their liability. And now today we will be studying about dissolution. So before we start about dissolution, can anyone tell me what is a dissolution? What dissolution means? Any one of you? What do you mean by dissolution?
So breakup of partnership.
किसी चीज को
हाँ बोलो बोलो कौन dissolution? What is dissolution?
Sir, officially ending an agreement, a business agreement or something.
Good, Faisal. It's a business agreement. You are signing some business agreement, and you are not at all on the agreement, so you are not at all, dissolving. What is dissolving? Dissolution is the word which has. But Fazal, what you have said is the start of it. Dissolution is the end of the agreement. Yeah. Anyone else? Anything else? Lucky Chaudhary. Lucky, are you there? हाँ जैन द्विवेदी आप बताओ. What do you mean by dissolution? क्या होता है?
सर किसी चीज को सर क्लोज कर देना और सर पार्टनर्स को उसी हिसाब से शेयर्स डिस्ट्रीब्यूट करके दे देना सर.
Okay. What else? अच्छा partnership को if we set aside, if we keep this partnership aside, what will be called as dissolution?
सर कोई चीज बिल्कुल खत्म कर देना ऐसा.
Speak in English and what actually dissolution is. Means with context to the partners, if we say let us just do not talk about partnership act, what is dissolution? Any one of you?
Sir, breaking down.
Okay, what else?
Sir, end of a business.
Fine. Yashasri, would you like to say something?
So dissolution means to, dissolve something or, to end, stop something.
To
stop something, to give an end.
Dissolution. Okay. What is dissolving? I told you, set aside this partnership. What will be, what is called dissolving? Dissolve.
So dissolve matlab, so it's like the end, matlab khatam ho jana.
खत्म हो जाना या वलीन हो जाना हिंदी में?
Sir, इतनी pure हिंदी से नहीं आती है.
Have you studied chemistry up till 12th class, up till your 10th class?
Yes, sir.
So what is solute, solvent and solution, and the process is called dissolution?
इतने ध्यान से नहीं पढ़ी थी.
Anyways, this word dissolving means, just for example, just if you take some example of a salt which you are going to dissolve in a water. So salt is called solute, water is called solvent, and when you dissolve it will, when you put the salt in it and then you stir it out, the thing which will be outcome will be called a solution. Okay, and this entire process is called dissolution, means you have dissolved something in the water. Okay, so when you dissolve something, what happens? The existence of that particular uh, salt is not no more there. It gets completely dissolved in the water, and you can see it. You cannot see it with the naked eye where the salt has gone in the water. Actually, it has changed the taste of the water, and the water has become salty, and the salt has completely dissolved in the water. Is it so? होता है ऐसा? So in the same way here also, the dissolution is something which is, vanishing, which was there in the existence before. Now it has dissolved. It has already gone. Okay, but I will tell you a philosophical meaning of this dissolution after some time. We will be. Let us just study some certain things, and I will talk to you about today about some life or something like that, because this dissolution is the last topic which we'll be studying in partnership. From tomorrow and onwards, we have to start our LLP, limited liability partnership. Maybe within 2 or 3 days we will be able to finish our course also, and the remaining classes we will utilize for our revision purpose. For I have to take some remedial classes also, that also I will take for some of the students. Some of you will only be just taken in those remedial two. Your HOD has requested that 2 class every faculty should take. So I will also take 2 remedial classes, and remaining classes will also be, there will be revision, or you can say there will be some case studies which we will be solving, as we will be doing in between, somewhere in between also. So we will talk about certain things, and we will do certain things, and you will enjoy it for sure. Okay, so that we will be doing. So fine then. So let us just let me just take you to the dissolution and the dissolution of the partnership as such. So dissolution is nothing but, you can say, you are very correct that it is bringing some things to end is called dissolution. Means there will be no more the existence of the firm. The firm will get dissolved. This we will be studying today. So the first most thing is section 39 actually talks about the dissolution of the firm, or you can say the dissolution of partnership between all the partners of the firm is called dissolution of the firm. Means if all the partners have not dissolved the firm will not be dissolved, but the partnership will be dissolved. So the partnership is a relationship between the partners amongst themselves, which has evolved by the virtue of the agreement which they have done amongst themselves. So if we talk about the dissolution of partnership, it is different from dissolution of the firm. If all the partners have decided just relinquish the existence of the firm, then it will be called as a dissolution of the firm. Otherwise, it will be called dissolution of the partnership. So dissolution does not necessarily follow because the partnership has dissolution does not necessarily follow because the partnership has ceased to do the business, or the partnership may continue for the purpose of realizing the assets. So actually, dissolution of the firm as such will not happen as with the finishing of the partnership, because there is yet to be. So what does this dissolution of partnership means? They have stopped. The partners have stopped doing the business now, but they are proceeding further with the distribution of the dividends out of the firm. So till the firm is dissolved, there is existence of firm as such. Okay, so the law of partnership makes a clear distinction between the dissolution of the partnership and the dissolution of the firm. So where the relation between all the partners come to an end, all the partners. Okay, so it is called a dissolution of the firm, which is given under section 39. So where there is an extension of relationship between some of the partners only, not all the partners. So it is a dissolution of partnership, because with all the partners there was one contract which was binding all the partners, and that partnership deed itself is binding all the partners. So even if one partner is removed from that partnership deed, or one partner is going away, so the entire partnership deed will be affected. Okay, so that will mean to dissolution of partnership, not the dissolution of the firm, because it is affecting the dissolution of that particular partner only. Okay, so just because of that partner, the firm or the agreement between all the partners has to be renewed. Okay, let us take it like that. So it will be a extension of relationship between some partners only. So that will be called dissolution of the partnership and not dissolution of the firm. So the dissolution of partnership may or may not include a dissolution of firm, but the dissolution of firm necessarily means the dissolution of the partnership as such. Next is your dissolution of partnership. The dissolution of partnership takes place even when there is no dissolution of the firm in the following circumstances. It means that still the firm is continuing, but the partnership among the partners have actually come to an end. So this can happen under the following circumstances. Number one, by the expiry of the fixed term for which the partnership was formed. So for example, the partnership is a particular partnership which is which will the term says that it will come to an end when there will be uh, uh, means when the time will be over. So the time for which the partnership has been started, the time is over, so partnership is over. Okay. Further, by the completion of the venture, for example, partners have started doing a venture, means suppose construction of an overbridge in Jaipur. So that construction of overbridge is over, all the things are over, so the partnership is over by completion of the venture for which the partnership was done. Next is by death, insolvency, and retirement. So 42 C, D, and E. In all these three cases, the thing is almost the same. Death of a partner, insolvency, and retirement. So what happens? One partner is either died or insolvent or has retired from the business. This will withdraw the partner from the firm. So remaining partners remain as such, but still this will term to be a dissolution of the partnership. So in all the above cases, the remaining partner may continue in the firm in pursuance of the agreement to the effect. If they do not continue, then the dissolution of the firm takes place. So firm is a larger concept, partnership is a smaller concept. So when dissolution of firm happens, the smaller concept also happens along with. But if the small thing happens, does not mean that the large thing will also happen. Okay, so there is a clear distinction between the dissolution of partnership and the dissolution of the firm. So this is your assignment. You have to write the difference between dissolution of firm and dissolution of partnership. Okay, so I hope Chirayu is there. If not, no problem. What I can do is I can just write it over here on your chat box. Okay. Distinction between okay, so dissolution of partnership and dissolution of the firm, you have to write the difference between these two. Okay. Yeah. So in the following cases, there is necessary a breaking up or extension of the relationship between all the partners, closing and closing up the business. So this is the dissolution of partnership, the circumstances of dissolution of partnership, and these are the circumstances of dissolution of the firm. So by mutual agreement, so all the partners have agreed all together to dissolve the firm. So that can be done anytime, right? So if it is regarding this, then it will be called a dissolution of the entire firm, because no partner now will be in existence. So there will be no partner of whom we can say that he is a partner as such. So that will be dissolution of the firm by a mutual agreement. So further, by insolvency, if all the partners but one, means all the partners or except one, all the partners have become insolvent. Okay, so firm will come to an end because the partnership firm cannot actually carry it on with one partner, because there has to be minimum two. So even if one partner is there or all the partners except one have become insolvent, then it will come to an end. Next is the business becoming illegal. For example, a business is of the liquor in Gujarat, and Gujarat government has announced that Gujarat will be a dry state. So in that case, what will happen? The business has become illegal. So in such a situation, when the business has become illegal, it has to be, it has to be closed down. It has the the firm will be wound up, or firm will be dissolved by the operation of law. Next is by notice of dissolution. So where the partnership is at will, the firm may be dissolved at any time by a partner giving a notice of intention to dissolve the firm. To all the partners, the dissolution will take place from the date mentioned in the notice. And if no date is mentioned, then the date of the communication of the notice. We have already studied this before. And I have told you that because of this clause, the partnership firm is at very high risk, because any partner can dissolve the firm. Next is, unlike the partnership at will, the partnership for fixed period cannot be dissolved by notice. So if it is a particular partnership, and that too which is for a fixed period, it cannot come to an end by a notice. So it could only be dissolved by the court by a suit by the partner, because fixed period has not yet is not yet over. So if the fixed period is over, it will come to an end automatically. But if the fixed period is not over, then it cannot be brought to an end just by a notice, because it is a particular partnership in which it is time bound. So everyone has to, everyone has to adhere with the time. Then only this type of partnership can further. That is the very much reason of having the partnership. And the time is not over, and in between somebody wants to terminate it, then the court will interfere, and through court only this can be done. Okay, so that's why it is called dissolution of firm through court. So next is when a partner becomes of unsound mind. So when the partner is of unsound mind, then also it will not dissolve automatically, because the lunatics, a person who is a lunatic, his legal representative through the court will ask for the dissolution of the partnership. And because it is through court, so that the date of the order of the court will be considered as a date of dissolution. Okay. Next is permanent incapacity of partner. The same is the case with permanent incapacity as the case was there for the insanity. So in that case also, if some partner has become blind or some paralysis has happened, then through court only dissolution can happen, and the partnership will be dissolved. All the assets will be sold, liabilities will be paid, and remaining share will be paid to the partner. Okay. Next is if there is a misconduct of a partner which is affecting the business, where the partner is guilty of misconduct, okay, which is likely to affect prejudicially the business of the firm. So if there is a major misconduct which has been done by the partner, and because of that misconduct, the firm name is at the stake, because he is the partner of the firm, and his name is at the stake because he has actually, he has done a misconduct. So that's why and in that case only the partnership will be over. Okay. So as for example, gambling, some partner has been caught doing a gambling, so, and one partner was traveling without the ticket. So these are the sufficient grounds, because this actually brings the defamation to the firm, and it affects the goodwill of the firm. That's why, because of these reasons, the partnership can be terminated, and these are the good reasons for applying court by the other partners. Okay. Next is persistent disregard of partnership agreement by a partner. So maybe one or two partners may be continuously not at all, obeying or not at all adhering to the provisions of the partnership deal. And again, they are breaking the rules, they are breaking certain things, and now it has become difficult for other partners to work with them. In that case, also the partnership can be dissolved by the order of the court. Next is a transfer of interest. So a partner normally is not at all allowed to transfer the interest in the partnership to someone else. So he cannot actually, he should not actually, transfer the interest to someone else. But at the same time, if some minor partner is there, okay, and how come minor partner is there? Because the father has died and that minor has to be admitted for the benefits of the partnership, and then this is something which is the situation. So in that case only the transfer of interest can be there in the partnership, otherwise not. Okay, but because of certain circumstances, certain things, by the order of the court, maybe in some certain other act also, and the order of the court is that all the property, all the interest, everything to some person has been transferred to someone else. In such a situation, the other partners can file a suit against the court, against this decision in the court, and can request for dissolution of the firm, because they may not be able to carry on their business with the new person, and they are not comfortable. See, partnership is an agreement, and it is, and the genesis is the, and what is the genesis of the partnership? Genesis is the mutual trust, and that's why this is the reason why the partners should not be transferred. They should not transfer their things to others. Why? Because with other person, that trust, that intimacy may not be there, and the remaining partners may not be able to carry on the business. So in case of transfer of interest by a partner, may it be done either by the partner himself or by the virtue of law, the other partners can file a suit for dissolution of the firm. Next is if the business is working for loss. So there is a substantial loss in the business, and business is continuously working for losses only. So in such a situation, what will happen? It is a sufficient ground to just go for the dissolution of the firm. Next, if it is just an equity. So if the grounds which are mentioned over and above over here means the lunacy of partner, insolvency of a partner, interest share transfer, loss, and all these things are not exhaustive. So the partnership can be brought to an end even if the court thinks that it is good to stop the this partnership. Now, when the court will think it and when the court is satisfied that it is just and equitable. For example, there was one case where one partner was having an illicit relationship with the wife of the other partner. So this is a sufficient ground that and there is a deadlock. There is something which the people have not at all. They are not at all talking to each other. Their talking conditions are not there. They have lost the mutual confidence and trust. So anything can happen, which is the basis of the partnership. If anything which affects the basis of the partnership, then in such a situation, this partnership can be over. Okay. Next is what will be the effect of the dissolution. Now, effect of the dissolution, we will go through. So, continuing authority of the partners. So, authority of the partners to bind the firm continues so long as the necessary to wind up the business. So, there is a dissolution of the partnership has happened, but a dissolution of firm is yet to happen. Then in such a case, what will happen? The time period in between will be the time period as is below, because partners have stopped doing their business, but any of the act of the partner will equally bind the other partner because the winding up process is still going on. So each partner will also be having the lien on the assets of the partnership, which and this entitles him to the payment of his own share and the debts to the other creditors and all that. So this right of lien cannot be actually it is with all the partners. So even if the the remaining partners are doing some unfair distribution. So whatsoever property is with the partner, with whatever partner, he can exercise a lien on it. Okay, and he can enforce the fair distribution of the property. Next is continuing liability of the partner. So partners continue to be liable to the outsider for any act done by any of them which would have been an act of the firm if done before the dissolution. So had the dissolution proceedings not been there, so they are equally responsible for all the activities done by them as they were responsible before as such. Okay, so their liability is equally same. Okay, the liability is equally good till they have dissolved the thing, till they have realized all the assets and have paid all the obligations and all that. Okay, till then they will be. So further, right to return the premium. Yeah, this is one of the important thing. So when what is this premium? Premium is nothing but the amount of the goodwill which a partner brings when he is admitted to the benefits of the partnership in between. So if some admission of partner is there, then he will bring some substantial, you can say, money with him. So he has to pay something over and above his share of partnership. So he has to pay something which is over and above his share of share of partnership. That is the share of the capital. This over and above item is called the goodwill. So the uh, the provision of partnership says that if some partner has brought the goodwill and the partnership, if and in such a situation, if the partnership is a partnership at it is a particular partnership for a period of suppose, for example, 10 years. Now after 8 years, because the time period is not yet over, and after 8 years, what happens that you tell the other partner to leave the business, or there has been some misconduct, or something has happened which actually is which actually forces him to just withdraw from the firm before the time period is over, except when there is an agreement or a debt of partner of misconduct of the party seeking the return of, means he himself has done any misconduct. Until unless these three situations are there, what law says that whatever premium he has brought, it should be returned back to him. So this is for sure. Okay. Next is the settlement of the accounts on the dissolution. So section 48 of the Act provides that settling the account between the partners after dissolution of the partnership, following the rules shall be there. So losses including deficiency of the capital shall be paid first out of the undistributed profits, next out of the capital, and lastly, if necessary, by the partners individually. So if the partner, if the funds in the firm are not at all sufficient to pay off the liabilities, in that condition, the partner has to, give the things from his own home also. Okay, so the assets of the firm, including the sums contributed by the partners to make up the losses, deficiencies of the capital, shall be applied in the following order. So first of all, who will be paid? First of all, outside creditors will be paid, and then the advances which the partners have given over and above their capital will be given, and then remaining money will be distributed among the partners. And if there is any surplus, then it will also be distributed in the profit sharing ratio. Okay. So where the assets are not sufficient, so if the assets are not sufficient, then the partner have to bear the loss again in profit sharing ratio. After they have contributed their shares to the deficiency, they will be paid rateably the amount due to them by way of the capital. Okay, and there is a Gardner versus Murray case, which is the genesis, or which is the basis of this piecemeal distribution, which you have studied in your accounting in 12th. Okay, I hope you have studied. I don't know, but I hope you have studied this Gardner versus Murray case, and the piecemeal distribution and all. I think you are aware about it. So accordingly, the distribution is to be done. So Okay, so if there is any loss in the distribution, so how it will be treated? So in case of the partners, is if some partner becomes insolvent, so what will happen? The other partners have to bear the loss of that insolvency. So in case a partner is insolvent and not able to contribute towards the deficiency, and the principle laid down in the case of garden mercy, in that case it will be applicable. What is that? The solvent partner will contribute only their share of deficiency in cash. Okay, the available assets should be distributed among the solvent partners in proportion to their capital. Thus, the deficiency of the capital of the insolvent partners will be distributed among the solvent partners in the ratio of their capitals. So in normal case, what is happening? The surplus or the deficiency, if no partner is solvent, it will be distributed in the proportion of the profit sharing ratio. But if any partner has become insolvent, in that case, the the share of the insolvent partners will be distributed among the partners in the ratio of their capital. Okay, so this is the Gardner versus Murray case. Next is about goodwill. So before we start, what is goodwill? And before we further start, what is a dissolution? What is the psychology or what is the philosophy behind the dissolution? We will discuss that. Okay. So what according to you is dissolution? Anyone? Come on. How life is related to this dissolution? You can say, how can you just take this dissolution?
Sir, goodwill is an intangible asset
Okay.
and it is a portion
What
of
discuss first
purchase
about goodwill?
price
No problem.
higher than the
Hello?
sum of the net fair value.
I thought you will be speaking something about dissolution. Fine, you want to discuss something about goodwill. It's okay. So what is goodwill, Dipti?
Sir, it's an intangible asset which is like it is a portion of the purchase price that is higher than the sum of the net fair value of all the assets
When a
purchased.
new partner is admitting in the uh, is admitted in a partnership, what are the circumstances we can tell him to just bring some more money because we have goodwill? What does this goodwill means? Can you see goodwill?
No, sir, it's intangible.
Can you feel goodwill?
No, sir. Yes, sir.
Okay. What is goodwill? Image of the company is called goodwill. If I say it like that, would that be okay, Dipti?
Yes, sir.
Okay. So image of a company which a company has created during the period of time is called goodwill. Right?
Yes, sir.
So why this image actually is called an asset? Why it is treated as an asset? You are saying it's an asset, intangible assets. Okay, मान लिया. Why this is called an asset? Anyone?
Sir, goodwill represents asset because it's never amortized.
Sorry?
So because it is considered to have an indefinite useful, I mean it's very useful and it's important for the company.
Mm-hmm. So when we tell some partner to be admitted, and we ask him to bring some more money which the other partners have invested, we want him to bring more than the usual, and he is ready to bring. Why will he be ready to bring that more money? Rishabh Goyal, you tell.
Sir, because he will get more share in future.
Hmm?
So as per his goodwill, and he will get more share in future.
थोड़ा जोर से बोलो बेटा.
Sir, I am saying that he will get more share in future as per his goodwill because his image is very good in the market.
No, he is getting, for example, there are three partners. Everyone has invested 10,000. Okay, for the sake of one third of share. Okay, all equal partners, equal amount. Fine. This new partner, we have told him to join. Okay, and he will be joining for 1/4 share. So he should bring 10,000, but I am telling him to bring 15,000, and he is happily bringing this 15,000 for the sake of 1/4 share. Whereas every other partner has also invested 10,000 only. So why this new partner should get has to bring more capital? Because and we are offering him one equal share. Yes, anyone? And that too, he is happily doing it. He is happily doing it.
Sir, I think because of the goodwill of the firm,
So
which
that
the
is goodwill.
partners
But
made.
I want to ask you, what is goodwill? Why this? From where this goodwill has come up?
Sir, it is an intangible fixed assets which gives the value, which tells the, I think, the value of the firm or the image of the firm in the market.
So how it is calculated?
That I don't know.
Huh? You
That I
don't know,
don't know, sir.
forgot. You
Sir,
say I
forgot.
forgot.
Sir, I forgot.
Otherwise you have studied this in your 12th class.
Yes, sir, I forgot.
How the goodwill is to be valued. See, when we say that a firm is having a goodwill, at that time, the firm might be earning enormous profit. Means the profit which a firm is earning in the market is more than what the other firms will be earning. Are you getting my point? So the profit which a firm is earning means a firm it is earning super profit. Okay, some profit which is beyond the normal profit. Market rate of return is 10%. So 40,000 is the capital and market rate of return is 10%. Or this the firm like this normally earns 10% market 10% profit, but our firm is earning 15% of profit. So why this person who is giving us more money is happily able to join? Why he is coming so happy that okay, no problem, 5,000 I will give. Why? Because this firm is having a capacity to earn more than usual. So this capacity to earn more than usual has come by the time. Why our firm is earning more than usual? Because the conduct of the business, conduct of the partners of the firm are like that, that it is actually conducting the things in such a way that the customers are more attracted to our firm, and they are paying also good, and their volume is also good, and their margin is also good. So that's why we are earning, and that is the reason why other partner is also joining. We have never asked him to join, but he is joining, bringing in the capital which will for sure be expanded. But at the same time, we have to ask him, okay, what extra are you bringing? This all efforts we have done up to पिछले 15 साल से हम लोग मार्केट में झक मरा रहे हैं, और अब यहाँ तक पहुंचे हैं, और उसके बाद में हम तुम्हारे को ऐसे ही कैसे अपने 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 इतनी सारी सालों की मेहनत का हिस्सा दे दे? So for something extra, you have to pay something. So this something extra which the other partner will be paying you is the value of the goodwill. Means it is something which is related. Suppose, for example, this partner is coming for 10 years. Okay, or you can say the super profit. For example, the other firms are earning 4,000 and we are earning you can say 6,000. So 2,000 is the extra this firm is earning. Okay, and this firm has been established from last 10 years. So it has taken 10 years for this firm to come to at this super profit level, and then this will be capitalized. So 4,000 multiplied by 10 years, it will be 40,000 is the value of the goodwill, and his share of goodwill will be 10,000. So 10,000 is his capital and 10,000 is his goodwill. So he will bring 20,000 in the firm. I hope I am able to make you understand this, that why and how it happens. Okay, so goodwill you can study yourself also, though it is not in your course too. Okay, so I was this chapter is over. We will be studying limited liability partnership tomorrow. And one thing I would like to just tell all of you over here is that I was talking about dissolution. So for studying dissolution, or you can say for understanding resolution for the life. See, we have studied partnership. So may the partnership is a partnership of life partnership, or you can say a partnership for the business. The crux is that the person should have a value addition in his life with the happiness in the partnership with more money and more share capital also. Okay, so when we go for resolution, तो क्या होगा? सब कुछ यहीं रह जाएगा. वो जो नमक था ना जो पानी में मिला था वो कभी दिखाई नहीं देता है. तो सब यहीं रह जाना है, इस दुनिया में ही रह जाना है. इसलिए अपने साथ ऐसी अच्छी चीजें संजोइए, एक दूसरे को प्यार कीजिए, प्यार बांटिए. ओके. और एक गाना सुनाता हूँ आपको पुराना, जो मैंने सुबह वाली क्लास में भी सुनाया था. आपने वो गाना सुना, कसमें वादे प्यार वफा सब? सुना है किसी ने?
Yes, sir.
ये वही वाला गाना है. ये पहले एडवर्टाइजमेंट आएगा, आपको पता ही है.
I love my credit card
ये
bill.
एक और.
Let me explain. Every time I pay my bill using credit.
Just listen some few lines of this particular song. Just listen this. तो आसमान में उड़ने वाले मिट्टी में मिल जाएगा, और इसी को डिसोल्यूशन बोलते हैं भाई. When you get dissolved in this soil, so from it will be
Nice song, sir.
in the square one itself from where we started. That is when partnership was not there, what was there? So everyone was having their own things, and then all people come together, had the partnership, and then one day will come when everything will be dissolved. The partnership will also be dissolved. Your life partnership will also be dissolved. And what will go along with you is the goodwill which you have earned. The goodwill or the value addition which you have done in your life and in your profits which you have done, that will again come back along with the money which you have invested. So that is the crux of this partnership which we have studied today. Okay. Yeah. Any question or any thoughts if you want to share? Jayant, you wanted to say something. Jayant Divedi. Anyone? Anything else? Okay, so should I just stop over here? Okay, and you might also
Yes,
be
sir.
feeling
Yes, sir.
hungry. Yeah.
Yeah.
हाँ बोलो बोलो जयंत, कुछ बोलना चाह रहे हो? और anything you want to ask? Fine. So let us just take the attendance. So just say yes, sir. Aditya Chopra, Akash Jain,
Yes, sir.
Abhay Singh Shekhawat,
Present, sir.
Abhishek Singh Sisodia, Adhiraj,
Present, sir.
Akash Jindal, Ayush Verma.
Yes, yes, sir. Akash Jindal present, sir.
Okay, okay. Azan,
Present,
Chirayu,
sir.
Dheeraj present, sir.
Dipendra Gujar, Dheeraj Lamba, Dheeraj Sharma, Dipti,
Present, sir.
Dheeraj
Present, sir.
Divyanshi,
Present, sir.
फजल,
Yes, sir.
गगनजीत, हार्दिक,
आस्क कर दे सर।
हर्ष टिमानी,
प्रेजेंट सर।
हर्षित गुप्ता, जयपाल सिंह, जयंत द्विवेदी, कशिश शर्मा,
प्रेजेंट सर जयंत।
या कशिश शर्मा, खुशी वाधवा, लगन महिपाल, लक्ष्य शर्मा, लकी चौधरी, मिहिर अग्रवाल, नमन जैन, नमन सिंह, पारिजा गुप्ता, प्रणव शर्मा, प्रियम सोनी, राघव मालवानी, राघव सिंगल, राजवीर
प्रेजेंट
सिंह,
सर। राघव सिंगल प्रेजेंट सर।
ऋषभ गोयल, ऋषि कानूनगो, ऋत्विक यादव, ऋत्विक सेठी,
सर मेरा नाम आ गया क्या? सचिन यादव।
सचिन यादव, सागर शिरवी, साहिल
सचिन यादव
खंडेलवाल,
सर।
संज्ञा गुप्ता। हाँ धीरज ठीक है।
प्रेजेंट सर।
सर संज्ञा प्रेजेंट।
या
सर सचिन
शशांक
प्रेजेंट सर।
मिश्रा,
ये
शिवांश,
कर
सर।
सुरभि सिंगल,
शशांक
गणेश अग्रवाल, विक्रमादित्य,
Present, sir.
विशाल चौधरी, यशस्वी।
लंबा।
ओके
Present sir, Yashashvi present.
या
आवाज आ रही
ओके
है
गाइस,
मेरी?
थैंक यू एंड हैव अ नाइस डे।
सर सर सर
हाँ बोलो।
सर मेरा नाम आ गया क्या?
कौन?
सचिन सर।
हाँ सचिन लिया ना,
थैंक यू सर।
सचिन ले लिया।
क्लास।
सर ये लांबा डिस्टर्ब कर रहा है फालतू।
क्या कह रहा है?
सर ये
Delete कर
धीरज
देगा सर
परेशान
class।
करता है सर, फालतू बीच में अटेंडेंस के बीच में बोलता है।
अरे यार देखो, सबको हक है बोलने का भाई।
सर तो फिर ये गलत बात है ना, मतलब मैं डिस्टर्ब हो गया, अटेंडेंस छूट जाती है मेरी।
अरे बेटा तेरी लगा दी मैंने 2 बार तेरा नाम, डोंट वरी।
अब अच्छे हो सर, अच्छे हो आप।
और धीरज तुम्हारा नाम आया तभी बोला करो यार, बीच बीच में नहीं बोला करो बेटा।
बोले कुछ करी पर देखा आपको आवाज आई नहीं है, क्या पता।